I'm Drew Stevenson. This is from my administrative law class. This is about the case Londoner v. Denver, a 1908 U.S. Supreme Court case about which types of agency decisions are adjudicative, maybe enough that the individuals affected have a right to some kind of in-person hearing to kind of present argument and so forth. So let's dive in. Now, the city of Denver had power under its charter to make infrastructure improvements like paving the roads, which needed to be done in 1908. And the cost could be assessed to the individual property owners that benefited from this. That's not that surprising. The case in your casebook sets forth in pretty tedious detail the process that there was a state Board of Public Works that would initiate this and estimate the costs and then define assessment districts and decide how much each individual property owner, depending on a host of factors, had benefited and what they owed. Again, it was a detailed process, but that's not our real takeaway from this case.
Got any paved roads?
Paved streets, shops, big houses painted white.
3 blocks of paved streets.
And in this case, the homeowners or the property owners affected were allowed to submit written objections, which they usually did by counsel, but there was no real opportunity for an in-person or oral hearing. So Londoner and some others had filed detailed written objections to their assessments within the allocated 30-day window. And they had asserted various legal objections through counsel. In the case, it lists these as it was illegal, void, uncollectible, arbitrary, disproportionate, exceeded benefits, based on unconstitutional laws, lacked a proper petition. You get the idea. And after written objections were filed, the city council met, and without any further notice to the homeowners or property owners, and without any other hearings, basically decided how much each property owner would have to pay. They sort of approved all the plans. The council adopted a resolution basically confirming the apportionment made by the Board of Public Works. Justice Moody wrote for the majority, holding that the individualized assessments were void because the individual property owners were not given any opportunity to be heard. They didn't get hearings to contest the amount, which depended on specific facts about each property. Here's a quote I pulled out for those of you who like to highlight in your casebooks. If state officials are quote, determining whether and to what amount and upon whom a tax shall be levied, and they're making its assessment and apportionment, and then due process of law requires that at some stage of the proceedings, before the tax becomes irrevocably fixed, at least, the taxpayer shall have an opportunity to be heard, and of which he shall have notice, either personal by publication or by a law fixing the time and place of the hearing. In other words, they have to have notice ahead of time. You can't just say, oh, we had a hearing yesterday, sorry you didn't know. You either have to publish it widely where people are likely to see it, if they're looking for it at least, like in the legal notices of the papers. You have to sort of give them notice directly, like mail it to them or email it to them. Or you have some sort of rule that says hearings are always on this day of the week at this time. It continues, even here, a hearing in its very essence demands that he who is entitled to it shall have the right to support his allegations by argument, however brief, and, if need be, by proof, however informal. In other words, they need to be able to present an argument in person and submit some evidence, even if we may not follow all the sort of procedures for admitting and authenticating evidence and proving up evidence and so forth that we would in a regular trial. Londoner establishes that when government administrative action is adjudicative, that is, it affects specific individuals based on their particular facts and circumstances, those individuals are entitled to some extra due process, even if it's not a regular full trial. In this context, due process requires more than just the opportunity to submit written objections. It actually requires a hearing where there's an opportunity for affected parties to present arguments and evidence. This case drew an important distinction between agency rulemaking and agency adjudication. When agencies make rules, it's a little more analogous to legislation, but when they adjudicate or make decisions that really affect one individual or sort of a defined group of individuals, these are more fact-intensive questions, and more process is owed to the people that are going to be affected by the decision that the agency is making.
Starting with Londoner v. Denver, and in the cases that followed, the Supreme Court created this dichotomy between two types of agency decisions or actions. One that we call legislative, which is basically when they're making general rules, and one that we call adjudicative, which is when they're making decisions in individual cases or for individual people. So how do you tell them apart? Well, I made this diagram to help make it clearer. And what we call legislative agency actions that are more rule-like, they are prospective or forward-looking. In other words, they're saying from this point forward, this is what the rule is going to be, or this is how the agency is going to proceed against violators, or this is what will create legal liability or count as a violation of the regulations. These apply to everybody. They're rules of general applicability, and the facts, if there are facts that give rise to this, tend to be general policy assessments or determinations like societal problems that the agency is responding to, or economic conditions, or the economic impact of a recent event. Now, adjudication is sort of the mirror image of this. It's retrospective, or looking backwards up to the present. And to give an example, in Londoner v. Denver, that would be how much did the city have to spend to pave the road up to and in front of your house? And because we're going to assess the homeowner that amount or some percentage of that amount. So this is an individualized decision. The outcome is going to vary from person to person, and it's going to depend on facts like who or what or where or when or how or why.
And that concludes our discussion of the case Londoner v. Denver. In a separate video, I'll talk about the companion case, Bimetallic Investment Company versus the State Board of Equalization.